Forces Agreement with the United States to deal with specific matters. That was what happened in 2015. You said risk. You said terrorism. By approving this, you are opening the floodgates to open this country to major risks of terrorism and its potential attacks and consequences. Mr. Speaker, therefore, since this treaty has not been executed by President Nana Addo Dankwa, the President of the Republic, we, the Ghana First NDC minority, we are unable to continue with this process. Take your majority decision, support the American government, do it cowardly as you are doing, do it, because give us an opportunity to improve it. The United States of America, why did they set up a Regrettable base? Because of abuses of human rights. You are opening the floodgates to Ghana for them to come and abuse us. The NDC minority, Mr. Speaker, I should have served you notice. This one, we won't be able to be associated with it, and we won't be able to take part in it. And therefore,
Honorable members, the House will remain suspended for 5 minutes. I will meet the leaders in chambers, and we shall resume after 5 minutes. Thank you very much.
I think $20 million being invested in the Ghanaian Armed Forces in 1 year is a pretty significant return.
$20 million for unrestricted access to the country?
No, it's not unrestricted access. It's only access to the bases that Ghana makes available to the United States for the exercises.
But you get to choose those bases, don't you?
The government of Ghana gets to choose those bases. Okay. And just as if you were inviting me into your home and you said, that's your bedroom, wouldn't you want somebody to knock before you came in? Well, that's my point. It's as simple as that. when we have people here, we want to ensure that we're cooperating, that we're working well together, but there's also a right to privacy.
But then you can bring everything into this country, take everything out of this country without anybody checking.
No, we can't. What we bring into the country is mostly left here, except for basic personal equipment, which people travel with all the time. And what we take out of the country, the Ghanaian government will know what was brought in, is going out. It's manifested. It comes in as diplomatic cargo. There's no secret about it. And if there's any secrecy involved, it's because the material is something that the Ghanaian government believes should be restricted for public good, so that our enemies will not know what the capabilities are.
My final question, sir. If you were Ghanaian, you've seen the document. If you were Ghanaian, would you think that this is a fair deal?
I have always thought it's a fair deal, and I think that when people see how it's being executed, they too will think it's a fair deal. In fact, I really sincerely believe that a payment of $20 million, an investment in Ghana's police and armed forces, is well worth public scrutiny on the one hand, and when people see the actual execution, they'll say that was a good investment.
This award, I wasn't here when you answered it. These awards, what do they mean? First of all, what's your own assessment of women's rights?
You're welcome back. And you had Minority Leader in Parliament, Haruna Idrisu, and you had the Speaker also calling for order as there was near chaos in that House. The walkouts were staged by the minority, and the majority, of course, had their say and had their way in addition to that. You also had the U.S. Ambassador to Ghana, Robert Jackson, also explaining the circumstances and trying to explain to understanding what it is that is not in the contract or the agreement that is being suggested out there in the public that is in the agreement. Now, let me introduce my guest to you right away, and I do not have a take this morning because our table is full. So, my guest this morning, our regular panelist and editor-in-chief of the New Crusading Guide newspaper, Abdul Malik Kwekubako. Thank you very much for joining us. He's got all the documents, past and present, as far as this matter is concerned, and very shortly he would, be laying them out and tell you his understanding of them. Also in the studio is lawyer Ace Anan Ankuma. That's it. Okay, I got to be careful. We're privileged to have the Defense Minister himself in the studio, in the person of Dominic Newsfile. Honorable, thank you very much for joining us. We thank you that you made time.
Thank you.
Also, former Deputy Interior Minister, James Agalga. Good morning.
Good morning.
Welcome to the studio.
Good morning.
Okay, so they are both MPs as well. And they were all in Parliament and have been part of all the arguments that have gone on. Well, before I start, because Dominic Newsfile is right here also, let me state this. If you go to the Ghana web page, there's a story that was put up this morning. Early morning, I was about finishing up my preparation. Normally what I do is I do all my preparation, and early in the morning I'll continue, and perhaps often will go to Ghana web and almost various different websites to check what is new that I may not know before I come to the studio. But I delayed a bit in doing that, and a former Attorney General and a very senior at the bar who I respect a lot and who mentors me silently in how to show a lot of respect to Ghana and not to win your argument by shouting, brought to my attention a story that, took a dig at the Defense Minister as someone who was unfit for his job. And so I called the attention of the Ghana web because they attributed it to me and I never authored any such statements. Thankfully, Ghana Web also has a true gentleman in an editor who took it down immediately and apologized to me. The story was originated by My News Ghana. My News Ghana, I think, yes. I drew the attention of the editor also to it, and I suspect by now he had done the honorable thing. Point is, in the heat of his press conference, he holding press conferences and speaking about the matters, a law teacher, Justice Shramsai, had comments to make and wrote profusely about it, and portions of it were being circulated. And what I sometimes do is that I put a post to elicit some views to assist my show. I visit various persons' website walls to be guided. Serious opinion holders on social media. So I also copied and put on my page and indicated clearly that I had copied from that person, hoping that I could read what the comments would be to guide me. So I have not authored any such statement. Thank you very much for taking the story down, and we can move on from there. I've told the Honorable, Minister that if I have views about how he does his things and I disagree, I'll share them with him privately, and that's true. I have views about how his posture to, speaking about matters, and I've told him I'll tell him privately. Unless he doesn't, then I may speak publicly about them. All right, so let's get to the matters that we have to deal with this morning. And they are first about the agreement between the United States of America and Ghana. It's a military, cooperation agreement that has various things about it that has engendered so much public debate and uproar. And the conclusion by those who are against it is that Ghana is simply selling its sovereignty to the United States of America. True or false? But this morning, more particularly, we will scrutinize that document and ask the question, what is in it? What is in it for Ghana? I'd like to start with the minister himself. You have had the opportunity of listening to what Ghanaians feel about this agreement. You have been compelled to hold a press conference and to state what are the facts. Despite that, there is still significant groundswell of public opinion against it, irrespective of the fact that the representatives of the people in Parliament, in their majority in the NPP, have approved same and ratified. Ghana Connects, a program on Joy FM, yesterday did, a survey. About 1,000 people contributed, and out of that number, over 80% were clearly against it. Now, convince this 80%, no matter how small the number is, why this agreement is okay and Ghana should buy into it as you have done.
Samson, thank you very much. And let me greet the people of Ghana and say clearly that the people of Ghana have the right to hold opinions for or against this agreement. And rightly so, because when the president appointed me as minister and this document came to my table, the Americans had negotiated with the Ghana Armed Forces a number of activities they will be doing going forward. Let me state that we've always had a security agreement with the Americans as a country. In fact, as a country, every president has always had a security agreement either with America or another country. From our first president, Dr. Kwame Nkrumah, till the current president, Nana Addo Dankwa Akufo-Addo, has always had security documents and security agreements with other countries. What we have never done is to share these security agreements publicly. This is the first time that a government has taken the deliberate decision to share this publicly. And I think that because it's the first time we had the unfortunate incident of politicizing that agreement, and it has led to where we are today.
But why will you share agreements that are supposed to be confidential, secret, publicly? Why will you do that?
You see, the Supreme Court of the Republic of Ghana takes the view that every agreement must go to Parliament. How does it go to Parliament? It goes to Parliament from Cabinet, with a Cabinet memo, and with a memo from the Minister. Once it reaches the realm of Parliament, and that's exactly what we did, we give them a copy. It is out of the jurisdiction of that minister or the executive. It is Parliament that squarely the foot is on. Parliament could have chosen to take the committee in what we call Committee of the Whole and secretly look at it, or decide that we believe that the first thing is to look at it publicly. But in this particular case, even before Parliament took that decision, some people leaked it to the media from Parliament. And that's what I'm saying that created all these problems. But let me go to the whole agreement itself. Our American friends brought an agreement with a preamble that sought to ask the people of Ghana that they wanted us to determine the status of their forces in Ghana, who will be visiting Ghana, because they've arranged a series of activities with our armed forces. And so when their soldiers come here, whatever number, whether 100, 50, 200, to do this work, what will be their status in Ghana? And secondly, they want to have access to and be able to use some facilities that are ours in Ghana. And they do not want to be able to use these activities within civilian areas, but within military installations. Remember that these facilities are ours, and they are asking us to allow them to use these facilities once they are here to do the work that they have agreed with the Ghana Armed Forces. This year, they have agreed to do 4 exercises with the Ghana Armed Forces. And when they come, the first one is about 200 soldiers. The second one, I think, about 150 soldiers. When they come to Ghana, what is the status of the average American soldier who's here? And what sort of facilities are we going to make available for them to be able to use? Full stop. That's what this whole agreement is about. So they come to say
why does the question of status arise? Because when they come, they are soldiers.
Yes. The status arises because there are certain benefits and certain privileges that they want from us. And in the agreement, they ask for certain facilities and certain benefits and certain privileges. And it's up to us to make a choice whether we want these facilities, we want these benefits to them or not. So when I met the agreement, and they had made copious references to earlier agreements that we have signed with them, which are still in force. In 1998, we signed an agreement with them, which is still in force. We signed an agreement, according to them, in 2001, which is still in force. In 2000, which is still in force. In 2015, which is still in force. And in fact, the base document that they use in preparing this agreement is the agreement that Ghana signed with them in 2015. Then Hannah Tete, she signed that agreement. But something, unfortunately, Ghana didn't have the copy of our agreement. The Minister of Defense did not have the agreement. The Armed Forces did not have the agreement. The Minister of Foreign Affairs did not have the Hannah Tete agreement. It was the Americans who actually gave us that agreement. So once we signed this agreement with the Americans and they kept a copy, Ghana simply did not keep any copy. Neither was Ghana aware, because it was not in my handing over nose. It was not in the handing over nose of the Minister for Foreign Affairs, and the Armed Forces didn't have it. So clearly, we didn't know that we had signed this agreement. And until the Americans made reference to it, and I said, come on, I don't have any idea. I wrote to the Foreign Minister, I spoke to her, she searched through her archives, she didn't have it. It was when the armed forces were meeting with the Americans over how to structure this thing a month ago in Stuttgart, Germany, then the Americans gave them a copy of the agreement, the Hannah Tete agreement. That's how we messed up ourselves as a country. That's the first thing.
But before that, you say that the 1998 the 2001, the 2000, 2001, and the 2015, agreements are in force.
Yes.
If they are in force, why do we need another one?
No. So the Americans are saying that, and it tells you in the last paragraph that once we sign this agreement, it supersedes all other agreements that we have with them. So they have boxed up every agreement that we have with them into one document, and consolidated it into one document, and are saying that we should sign. When the agreement first came, the reason why it was in my ministry for a year and a half, it's very simple. When the agreement came, I looked at it as any other Ghanaian and had concerns that why do we want to give you immunity? Why are you saying that if somebody were to die, we have we cannot sue you? Why are you saying that we should allow you to come, when you come as soldiers, maybe, of course, the soldiers move in large groups, they put them in an aeroplane, they come. They shouldn't come with passports because my ministry has no control over that. Why are you saying that we should allow you to carry a gun when you give orders? You have no even the respect of saying that you should consult Minister of Interior. I had concerns. Why is it that the Ghanaian soldier, if, for example, is going to America in large groups to do an exercise, you are not also giving the same conditions to them? Even though technically I know that our defense advisors, what we call the DAs, and their staff are given the same diplomatic status in America. But then, when we are also going in large groups to America, for example, for an exercise, I expected that we should also have the ability to go, not with our ID cards, our passport, but with ID cards. So I have concerns. Something, what I did, and I told them was that I'm not in the position to sign this agreement unless I pass it through the normal channels of scrutiny. There are levels that I want this agreement to pass through. And if this agreement is able to go through all these levels, then I'll know that the people of Ghana truly want this agreement. If they agree, I will start the process. If they don't agree, I'm sorry, I'm not sure that I'll be able to process with it. And that's why I said that it stayed in the ministry for close to 2 years, 1.5 years. Since I came, I met it. Samson, the first thing I did was to start engaging them. So I wrote to them that they should be very clear with me whether it was a base or it was not a base. And the American ambassador wrote clearly to my office to say, look, we don't intend to have a base. We haven't asked for a base, and it will not be a base. It is a facility at the Ghana Air Force Base, which we have used several times that we are asking. In 2015, Honorable Alex Segbefia, through a letter, granted Americans the opportunity to stay in Ghana for a period of 5 weeks to fight Boko Haram in Nigeria. So Ghana was used as the base to fight Boko Haram in Nigeria. And it was the deputy minister then who wrote that letter and gave them, they staged it, they brought their aircrafts, they used that facility for that 5 weeks so that they could fight Boko Haram in Nigeria. So the Americans pointed out to me that it is the facility that sometimes they use, and they have been using it anytime they are in Ghana, that they are saying that instead of allowing other countries to have access to that facility, we alone want to take that facility and be using for our work with you. That's basically what we call the agreed facilities they're talking about.
Would there not have been a reason? You have sought for clarity and you have been giving so in writing. Would that not be a reason to ensure that that would have incorporated into the terms of the agreement, so that you are clear that this is not a base? Then the argument will not arise.
I'll come to that. I'll come to that.
Because you have that explanation. Yeah. The others who saw it and equated it to a base don't have that explanation.
I'll come to that.
Okay.
I'll come to that. So, again, I wrote to the Americans to let them understand that I needed to pass this particular agreement through all the channels. They wrote back to say they are amenable to that, and that they are amenable to every negotiation that we could go through. Samson. So I then told them that they should get a team from America, and we'll get a team in Ghana. So I wrote to all the ministries concerned: Foreign Affairs, National Security, Interior, the AG, the armed forces, every ministry concerned, and they provided me with a technical and a person to come and form our team. There were 12 of them. I have the names here, but I will not mention them. It's not good. Their names and numbers, or we took a role. So we had our team, and the Americans had their team. And then we're negotiating one by one, clause by clause, clause by clause, clause by clause. The original agreement was worse than this. Some clauses, we took them out, some we brought them in. And so we negotiated until we got to where we are. Because remember that this template is a standard template that Americans use all over the world. And the Americans have this particular one.
You had actually said it was not different from the previous ones.
No, I'm coming. I'm saying to you that it's a template they have been using across the world. If you check the Senegal one, as if you read the Senegal one, you think you are reading the Ghana one. If you read the one that Estonia signed recently and what the minister went to America and was announcing it public to the world, you think you are reading the Ghana one. If you read the Spanish one, and maybe I'll download it for you, you think you are reading the Ghana one. If you read almost every one that they sign, you think you are reading the Ghana one because it's a template that they sign with everybody. The only country that managed to force them to negotiate was Ghana. And the ambassador was surprised. Why Ghana wanted to negotiate.
If all of them are identical, then I doubt what work you would have done through the negotiations.
I'll come to that. Okay. I'll come to that. For example, the one that we signed in 1998 said that they could hold guns if given by their orders. That means that once the Americans ordered them to hold gun in Ghana, we hold a gun. And it's still in force. We are those who signed it in 1998. The NDC government then, Regrettable was the foreign minister. He signed it in 1998. But what we changed in this current agreement is to say that they must consult the appropriate agency in Ghana, which here is the Ministry of Interior. So they cannot just come to Ghana and start issuing orders that hold a gun until they get that license from the Ministry of Interior. I don't know whether you get what I'm trying to say. That's the difference between the 1998 one and the enhanced one we managed to insert. But I'll come to each clause by clause that we are talking about. So Samson, we did the cleanup that we thought we could do. Then we then took it to the Armed Forces Council. The Armed Forces Council is made up all the service chiefs, the CDS, former retired generals, the Vice President, the Minister of Interior, Minister of Foreign Affairs, Minister of Defense. We looked at it and we approved of it after we did whatever we wanted to do there. From the Armed Forces Council, it then went to Cabinet. Cabinet also looked at it. It stayed in Cabinet for over 3 months. We did whatever we wanted to do. The AG brought her opinion. Everybody, we did whatever we wanted to do. And then finally, we took it to Parliament. Of course, Parliament used 3 days to consider it and approve it. My ministry stays very long. Stayed in the Armed Forces Council for some time. Stayed at the Cabinet for a long time. But of course, Parliament decided that they would approve it within 3 days, and they did. What I'm saying is that at every step, I ensured that it was no more just a decision of the Minister for Defense, but that it was the combination of the voices of the people of Ghana that would approve or disapprove of this document.
Okay.
And for me, one of the reasons we believed strongly that it should be an open debate was to ensure that Parliament, members of Parliament from all sides, both at the committee level and at the overall Parliament, that's the House itself, would be able to factor their views into this. So they needed to reject it or approve of it. In fact, even at the committee level, you can ask them. They made some changes to some of the portions. At that time, I had gone out. When I came back, the army generals convinced them that the way it was much better. And they rescinded their decision at the committee level. Okay. But we'll get to the individual
we will get to that, and I'd like you to pause here briefly before we get into what happened in Parliament and the processes leading up to the ratification yesterday.
But just something. I think that the Ghana, I've said it over and over again, the Ghana Armed Forces and the ministry, especially this ministry, never negotiated this agreement on the basis that we're going to get $20 million.
Okay.
I think
we'll deal with that.
Wanted to
we will deal with that. We'll deal with that. if you hear how the U.S. ambassador put it,
I listened to
if you hear how he put it, people are not wrong to say that that is what it is. Now, James, well, what are the points of disagreement by the minority? I want you to help our viewers and listeners again by restating these points in a manner that all of us can appreciate.
Okay.
Which clauses do you have problems with, or it is all of them? Is it, for example, the Articles 3, Articles 2, 4, 5, thereabout, where they are going to have access? For example, Ghana hereby provides unimpeded access to and use of agreed facilities and areas to United States forces, United States contractors, and others. Are these shared with us?
Yes, thank you very much. The views of the minority are very simple and straightforward. And those views are, first of all, to debunk the argument that has been made all along that Ghana has previously had the same, if you like, agreements with the United States government, and that those agreements remain in force. Samson, if you look at the agreement that was dealt with by Parliament yesterday, it's obvious that it's not the same agreement that we were called upon to consolidate.
By the title?
Yes. Even if you look at Article 2, it's very clear. Article 2 talks about the purpose and scope.
Right.
And in Article 2.1, you see, it's very clear. Let me read for the benefit of our viewers. This agreement sets forth a framework for enhanced, my emphasis, enhanced partnership and security cooperation between the parties with the aims of strengthening their defense relationships further and addressing shared security challenges in the region. And it goes on and on and on.
Will enhance.
And enhance.
Will enhance, not be what he meant when he said a consolidation of these previous, documents.
Whichever way you look at it, from the wording of Article 2, there are fundamental differences between this agreement, the 1998 agreement, and the 2015 agreement, which is attributed to Honorable Anatete.
Okay, you say the previous ones were not binding. Can you establish that too? Because you have shown that this is a point demonstrating clearly that they are not the same as he claimed.
Yes, and I haven't said they are not binding.
Point that shows that they are not the same?
I haven't said they are not binding. Yes, several points. Several points.
At least,
for instance, let me take you to Article 5. If you go, the whole of Article 5 marks a fundamental difference, and that is the point of departure. Article 5.1 gives the United States Armed Forces unimpeded access to and use of agreed facilities and areas to United States forces, contractors, etc. Then you come down to, and it further states in 4 that United States forces are hereby authorized to control entry to agreed facilities and areas that have been provided for exclusive, my emphasis, exclusive use by the United States forces, and to coordinate entry with the authorities of Ghana. If you look at these provisions, you are giving them unimpeded access, you are giving them exclusive control.
Unimpeded access to what?
To agreed facilities.
So the facilities must be agreed?
Yes.
So where's the problem?
Yes, you would agree, but the moment you agree, they, in 4, would now have exclusive control and use. But that is the point Ghanaians are worried about.
If you're a landlord and you let to me your facility, your house, must you have access to that facility?
Not when you are talking about the armed forces of another country.
Okay.
Because if you look at our constitution, you see, armed forces are supposed to be raised and maintained by the government of the country. No any other grouping is allowed to raise an armed force. So if you allow the armed forces of another country to have
Okay.
exclusive control and access to facilities within the sovereign
with respect,
territory.
just hold on briefly for me. I understand that your microphone is beginning to misbehave.
goodness.
So hold on briefly. I'll return to you to canvass your points. They are coming. The technicians are coming to tweak it so that we can hear you and hear you clearly. Now, whilst we're waiting for James Agalga, the former Deputy Interior Minister, to recanvass or to continue with his points, he's shown to us, first of all, that the documents as claimed are not the same. He's giving us 1 point. Now, this is an enhanced one, unlike the previous one. So that's a point that shows that it is not the same. He will show us 1 or 2 more points to show that they are not the same. And then he will proceed to show us, demonstrate to us when he says the minister is wrong when he claims that they are binding on us. The previous documents are binding on us. Now, let me come to Ace. Ace has read and has annotated his copy in front of him. So, Ace, now look at our audience and presume them to be persons that have a difficulty appreciating these terminologies and assist them. Where are the problem areas that the minority mentioned? What are they, and why are they problems or they are not?
Well, James is right to an extent that the agreements are not exactly the same. Exactly the same.
In form or content?
Both.
Okay.
You can, if you're consolidating various documents, you put and pull. Some of the clauses might conflict, and so you take them out. There's chopping and changing around. So he's right. The 98 document is essentially 1 page. But at the heart of the 98 document is this whole cooperation agreement, which is replicated in the 2018 agreement, right? So on that basis, there's some, of course, he's right on the issue that this one doesn't specifically say that there will be agreed facilities that you have exclusive use of, or once we agree, you are given unimpeded access. But you're right, the unimpeded access is limited to agreed facilities, so that if we agree that you would have access to this zone, then we will not thereafter seek to impede your access to the zone. I just want one thing to be made clear. And he's also right to another extent. This agreement has a clear termination clause with a year's notice.
The 2018 agreement.
With a year's notice.
But is that not too much?
If it's a tenancy, I'll say 1 month or 3 months.
Of course.
If it's military with accoutrements and everything, I'm not sure whether the 1 year was long enough. And these are questions that we probably should get from the answers we should get from the minister. Why they thought 1 year and not maybe 2 weeks. But that is at the heart of
many years of practice. Is this not unprecedented? 1 year's notice.
In some of these things, I think that my practice, I haven't dealt with military contracts. I've dealt with licenses and leases and possessions, etc., etc. It depends on the bargaining power of the parties. I'm coming to a point. My major disappointment with this is the speed. Dear Parliament, the minister says it spent 4 months on his desk. Before 2 years, it went to cabinet for 4 months. At the time he finished reading, he sent it to Parliament. What were you in a hurry for, James? You are all in Parliament. Why were we rushing? Because the people of Ghana are encountering this for the first time. You should expect that we will balk at it.
They trust that the ministry, the minister, and the ministry and the councils that were involved and the teams that have gone through the negotiations would have done a good job.
Well, no, but after we read it, there was a general, everybody will admit that questions started being asked. My first reaction was, when their president called us a certain name, what does he want from us? That was my first reaction. Then I sat down and said, take it easy, go into this thing. Let's go back a little bit. As far back as 1962, and okay, before I get back to 1962, the critical issues here has a bit to do with the diplomatic immunity we give to them, right? so that if they commit offenses here, we can't try them, etc., etc. In 1962, a couple of years after we became a republic, we passed the Visiting Forces Act, which means that we've always had this issue with foreign forces coming to Ghana. It happens routinely. Some come for a couple of days, some come for a few months, some could be years. And
not for America only.
Oh, no, visiting forces.
Okay.
And as a matter of fact, I first came across this Visiting Forces Act in that issue, the Argentina issue. That's the first time I saw the act myself. This is not taught to us in law school. I came across the act, and we considered it very carefully to see whether that stopped Ghana from what happened. Now, the critical thing about that is we decided in 1962, and it is still law. Somebody said, but this is a 1962 act. But the guy who said it's a doctor, and I said, unlike your medicines, yes, unlike your medicines, laws don't expire until we repeal them. So maybe
Kweku has printed a copy of that.
No, Kweku has it. I have a copy here as well.
Okay.
And there are two critical things in that act. One, that if they commit offenses in Ghana, we are dividing which offenses we can try and which offenses they try themselves by what they call the service courts. And so if the offenses have to do with their people, and their property, they will try them, even though the offenses take place in Ghana. But one critical one, which had always not in my mind, was that an act done or anything omitted by the discharge of an official duty. So that if the visiting soldier is conducting an official duty and commits an offense, anything, an act or anything omitted, then they get to try. Any other offense is tried under our criminal code by the Ghana courts. So maybe if he steals, that one you can't say that it was in a discharge of official duty. But so it means that if he's driving his car and he drives recklessly and hits my car and somebody dies, his service court will try him. But then we put in a clause, said, no. If what he does affects a civilian, then our defense minister and the head of the visiting forces will sit down to discuss whether they try him or our courts try him. And having put this law in place in 1962, this is under Kwame Nkrumah. Then we put in a clause which says that, but although we are sought to divide our criminal jurisdiction in case there's an offense in Ghana, we can enter into an agreement to alter this. It says this section shall have effect subject to an agreement between the Republic in respect of the visiting force and the sending state to which the force belongs. So that actually the basis of these agreements that we've been entering into, whether we mention them or not, is actually section 2.4, which gives us the power to alter this division of which I find a bit unacceptable, to alter this separation of jurisdiction by an agreement. The next one that caught my attention then and still catches my attention has to do with bearing arms and engaging in military training. Now, under our law, that will be offenses. To bear arms in Ghana unless you are licensed, and if you engage in any military training. The whole thing about the South African forces who were deported, it was because they were deemed to be engaging in an illegal military training. We specifically authorize them to do it by saying that our criminal law on bearing arms and holding military services, military training, will not apply to visiting forces. So, ladies and gentlemen, newsflash, and I know people don't like me when I present the law this way, but this is what it said: the provisions of the Criminal Offences Act, 1960 Act 29, relating to military training and exercises, and the carrying of offensive weapons, shall not apply to a member of a visiting force acting in the course of official duty.
Voila. So what we have put in this agreement is needless, repetitively nonsense.
No, some of it, because they've added others. Some of it is based on law. Yes. But clearly, under this scenario, and I suspect several scenarios that you and I are not aware of, our government have entered into it and built on these. So there's that history. So I came to look at the 98 agreement, and you're right, it's not the same. It's one page. But the heart of it is still the heart that is beating today. They've added to it things that we ought to be concerned about.
Okay, so do this for me quickly.
Tell me.
Article 15. What is your interpretation of Article 15 as compared to... Yes, as compared to this law you refer us to. Now, it says that other than contractual claims, the parties waive any and all claims against each other for damage to or loss or destruction of property owned by the party, or death or injury to any military personnel and civilian employees of either party arising out of the performance of their official duties in Ghana.
Okay.
What is the meaning of this in the face of what you just read to us from our own law, not the agreement?
It follows from something else. This doesn't hang on its own. You see, under the Vienna Convention, military people are not entitled to diplomatic immunity.
Okay.
And very early in the Argentina case, they tried to set up the argument that the vessel had diplomatic immunity. It immediately got shut down.
Okay.
So if you decide to extend the Vienna Convention, and we also have a Diplomatic Immunities Act based on the Vienna Convention, to anybody other than a straight-out diplomat, as is defined, you need some laws to be complied with. In Ghana, in the past, it was the foreign minister doing it alone. But in a couple of recent decisions, the courts have held that the foreign minister can't sit in his office and grant diplomatic immunity. There ought to be a parliamentary process. So a lot of the diplomatic immunities we have granted, if we got into it, will not have the force of law.
Okay.
So to the extent that some of these agreements didn't go to parliament, the diplomatic immunities we purported to grant to military people before now were all invalid. You see, that's the problem when our governments don't comply with our own laws, or we pretend the laws don't exist. So let's get to these claims arise from diplomatic immunity. So if there's a diplomat in Ghana and he rents my house, that's a contractual claim. I can sue him if he doesn't pay. But if we have an accident, Ammon and Cats, Ammon versus Cats, we can't pursue the claim. What you do is that in our courts, you pursue back channel claims. Here, and James, you guys also did the same thing here. This waiver.
Then in the 80s.
Finally, the embassy proposes that both governments waive any and all claims other than contractual claims, the same language, against each other for loss, damage, loss, destruction of property of the Department of Defense or property of the military of Ghana arising out of, related to official duties, injuries suffered by military personnel, etc., etc.
Okay, and what is just read is the 1998 agreement
between us and them.
Right.
And I said portions of people have been.
Right.
But these are necessary incidents of the diplomatic status.
That's all.
That is where I made a point that Parliament, you should have given us more time. Because then we will say that if the government of Ghana is going to grant these waivers and immunities to these soldiers, please give us an Indemnities Act, by which the government of Ghana says that if I'm driving my car and I run into an American or maybe Russian or Canadian vehicle here on the basis of this agreement, I can proceed against government of Ghana.
Okay.
Because what happens in the normal diplomatic world is that you don't go to court. They do backroom channels. Our Ministry of Foreign Affairs will deal with them. It can take years.
I'm returning to Agalga now, but if you can do this quickly for me. Article 18, still around same issues that people are really enraged about. Settlement of disputes. Any dispute regarding the application, implementation, or interpretation of this agreement or its implementing arrangements shall be resolved at the lowest level possible and, as necessary, elevated to the executive agents for consideration and resolution. Those disputes that cannot be resolved by the executive agents shall be referred to the parties for consultation and resolution as appropriate and shall not be referred to any national or international court, tribunal, or similar body, or to any third party for settlement, unless otherwise mutually agreed.
Let me irritate. Read the one Hannah Tete signed. Then
This is 2015.
2015. So that you can join the two together. No. You let
Wait, let me read. 2015.
2015. Wait.
2015. This is security of information.
Yeah. This is the document Hannah
Which
Tete
provision is that?
Security of information.
Article what?
Yeah.
Article. That's Article
that's
6 or so.
No, here.
Right. Article 6, it doesn't say whether it's clause 2 or so. It says that
No, I just wanted you the two to go together.
it is the intent of the parties.
No, any.
Where is it? Okay. That's okay. That's is that Article 9 or 8?
Yeah.
Interpretation, amendment, and revision revision of information. So, Article 8.1, any disagreements regarding the interpretation or application of this agreement, any implementing arrangements or transactions executed hereunder shall be resolved through consultation and negotiation as necessary between the parties and shall not be referred to any national or international tribunal or third party for settlement.
Okay,
so they are the same, but there's a bit of an improvement here.
There's a bit of, you're right.
I just want
Unless otherwise mutually agreed.
Agreed. So
we added this one.
Yeah,
Okay.
So here,
But you see, you need to look
Wait,
at
I'm coming to you right away.
the
I'm coming to you right
the
away.
purpose of this act.
Let Ace tell us what
it-
the implications of
Now
this
you
are
see,
for Ghana.
That is why Parliament should have given us more time. Because then Ghanaians could have digested this. And maybe explanations could have been given. Or maybe changes could have been made to this and the language of this. This language is American. To the extent that even the spelling of material is material with an E instead of an A at the end. We did some changes, but we did not imprint ourselves on this. And so when somebody reads something which says disputes will be resolved at the lowest level possible, it sounds snobbish. But if you sit down and look at if Ghanaians had explained to Ghanaians that, wait a second, there's this escalating dispute resolution process, which you start with negotiation, you might do mediation before you hit arbitration, and once you hit arbitration, you actually exclude the courts.
That's right.
That you could do those by your contract. The court may not be bound by it. There's all the jurisprudence on that one doesn't have to go through. So if we had had more time, then maybe Dominic could have explained to Ghanaians that because they found this unacceptable, they tagged in something that, well, if we get there, we can also agree that we'll go to a court or third party. But then someone should have come in to say, yes, this sounds nice, but an agreement to agree isn't valid as in a contract unless it's supported by consideration. So simply putting unless otherwise mutually agreed there doesn't help. In fact, it's mutually agreed, so if they disagree, you won't go. So it looks nice, but we all have been given the opportunity, Parliament, for all of us to have the time to read, digest, ingest, and contribute to this. Maybe all of us, insignificant us, could have helped you. You went and read your thing in 3 days.
Thank you, Ace. And Ace says we should leave this discussion to military experts. Sorry. Sorry, we don't agree with you.
But that's an unfair representation of what I said.
I see.
You see, then this is what happens in this, and it includes Joy. When they've had an interview of you, they sit down and write your words the way they understood it.
Like they did to me recently.
And they make a headline out of it.
I'm even going to complain about what they did to me.
You get
what did they do to you? You said you were unaware of
content.
This 2015.
I didn't say I was unaware.
May I tell Joy what this
Then why
is?
didn't
Now,
you tell us?
your host was pinning me to a yes or no. My point was that one of the things that the media had failed us on is that we haven't heard from the experts. Now, on the technical military side of this, who am I?
Okay.
So on those ones, we should hear from the military people. But in course, in the normal sense of law and reading this and understanding.
So they reported you, but not in full. In James, they reported you, but not in full.
Which is false. Which is false reporting then.
Thank you.
The next time they call and one doesn't pick the phone, they will understand why.
Sorry, please, we'll get there. We are taking
the question you asked, James, I think you should continue with that question.
No.
You should point out the differences so that we will
deal with that.
We'll deal with that. You've had your turn.
We'll deal with that. We'll deal with that.
Something.
Okay, so.
And let me continue from the 18. The 18 is clearly an ouster clause.
Article 18.
Yes.
All right.
It ousts the jurisdiction of our courts.
It has been improved from what previously existed.
The 2018 agreement was a logistics support agreement.
You mean 2015?
2015 was a logistics support agreement. The U.S. could supply the Ghana Armed Forces with logistics and vice versa. In fact, for money. For money. So how do you compare a logistics support agreement to an agreement which grants the United States military unfettered, unimpeded access?
Can I do something rude?
Senior,
can I do something rude? Just a
no,
question.
no.
Senior, can I ask a question?
Let him ask him. Hold on.
If you do that, it's not fair to me.
It's okay, hold on.
If you do that, it's not fair to me.
Let's just ask a question. Once you give them diplomatic immunity, doesn't that follow even if you don't say it?
Okay, thank you.
Sorry?
That's why you should listen. that once you give them diplomatic immunity,
Yes.
doesn't that automatically oust the jurisdiction of the courts, even if you don't write it?
Okay.
Well,
Thank you. So now,
Ace will listen to you. Yes. No, let me build my point. I'll come to that. I'll address the issue of diplomatic immunity. So 18 clearly was not captured in the. If you look at the Vienna Convention itself, and Ace, you should look at the Vienna Convention, and you would notice that there are conditions under which even the diplomatic immunity granted to diplomats could be waived
By their countries.
when
Not by the host country.
when no host countries can make a case
Then they make them
for
leave
waiver
immediately.
when certain conditions
Yes.
are met.
Yes.
So it's not as if when you are granted diplomatic immunity, it is all in all. You see, so but let me continue.
Right, go ahead.
As you had your turn, let me
Go ahead,
continue.
go ahead.
So 18
Don't worry,
clearly is an ouster clause. If it is, it forms the basis for the ouster of the fundamental rights of all countries that have entered into similar agreements with the United States of America. And that is our beef. He mentioned a number of countries. Estonia. Why? Estonia has done what they have done because of the fear of invasion by their former bosses, the Russians. What is our fear? What is our fear? You go to the Philippines and see what is happening. There are a series of demonstrations ongoing because of the violation of the fundamental rights of their citizens who cannot even access the courts to vindicate their rights. Is that what we want to do in Ghana? But let me take you to another very important article which doesn't find
Then after that,
expression in any of the agreements that
after that will be your
the
third
minister
point.
relies
That will be your
upon.
third point, demonstrating the differences.
Yes.
Then you now tell us why he lied or was untruthful when he said we were bound by this previous agreement.
Right. Let's go to 7.
Article
Prepositioning and storage of equipment, supplies, and material. Spelled the American way. The United States forces are hereby authorized to preposition and store defense equipment, supplies, and material at agreed facilities and areas. The prepositioned material of United States forces and the agreed facilities and areas or portions thereof designated for storage of such prepositioned material shall be for the exclusive use of United States forces. United States forces shall retain title to and control over the use of prepositioned material and shall have the right to remove such items from the territory of Ghana. The material has not been defined in this agreement, even though there is an interpretation article.
So what's the big danger?
The big danger is that what we have done could allow the Americans to bring into this country nuclear weapons, chemical weapons. And you know the dangers associated with that? You know the dangers. You know the dangers. You know what is happening in Syria with chemical weapons. So you cannot go into an agreement which has the use of terminology that you know next to nothing about. And I interrogated the generals who appeared before us, and nobody had a clue as to what, including the honorable minister, regarding the exact meaning of material. So this is a fundamental difference between this and the previous agreements that we went into.
But why the suspicion? And is it not extreme in the manner that you purport to interpret that clause?
Why? Something. Why? If you have an article which purports to grant United States forces authorization,
whatever, for
yes,
what?
because we're talking about defense equipment, supplies, and material. What is the meaning of material? In fact, Mark, look at the spelling.
What will trigger?
The spelling
give us an example.
It's not the same.
Give us an example. What will trigger or inform bringing in such material?
We could be used as a launch pad to invade other countries, or governments in this country could even be toppled, and we've seen that happen elsewhere. Why? I mean, let's say this in all truth and sincerity. You know what happened in Côte d'Ivoire? The French military, based in Abidjan, overthrew a certain government. So why? Today,
we are an established democracy.
Today things could be rosy. You don't think about tomorrow. You never know about tomorrow.
Such fears?
Oh, but they are genuine fears because it's happened before. We should be guided by lessons in history. Shouldn't we be guided by lessons in history, Samson? We should. In Panama, a certain president was arrested. Why do you think it was easy for his arrest to have been effected? It is probably because they had military facilities of the kind that we intend to grant them access to in this country. And that is why Ghanaians think, the minority felt strongly that with all these provisions taken into consideration,
we will come to look at the report.
Is a state.
We'll come to look at the report that you were a part of as a minority.
Yes.
But now demonstrate to us why you say he is wrong or the ministry is wrong when they say Ghana was already bound by previous agreements.
I haven't said that.
Oh,
let's do the correction.
The sticking point for you. When you started, by your introduction, I asked you what are your concerns.
Yes.
And you named two.
No, I sought to distinguish.
The two were the question of sameness or similarity, and that it is binding.
Well, no, I'm talking about this because he made the argument that the hands of Ghanaians was tied.
Yes.
You see? And so there was no way, there was nothing that could be done about this agreement. And so when I said that that particular assertion is an untruth, it's based on the fact that this is an agreement in his own words that they negotiated. Various ministries, the Attorney General's Department, Ministry of Interior, Foreign Affairs, came together and negotiated.
You could be bound, but there will be room for a negotiation.
The previous agreements I have demonstrated are not the same as this particular agreement.
Clear. That is clear.
You can't compare, logistics.
You have faulted him that
logistics
the claim of the binding nature of those agreements is faulty. Demonstrate that it is something. It is untrue.
I think maybe we didn't understand ourselves.
Okay.
I have never run away from the fact that there is in existence an operation, a 1998 agreement. I have never said anywhere that the 2015 agreement was not signed between the two countries. I have sought to distinguish the 2015 agreement by stating that that was a logistics support agreement, which has no bearing whatsoever on this particular agreement that we passed yesterday.
Okay.
98 agreement, yes, there are some similarities, but fundamental differences.
Right.
Okay, and so it is the fundamental differences that I have been highlighting.
What would you say to one other critical point? That they tell you that in this agreement, they have introduced a termination clause, which never existed. So we are improved. So this, in fact, is an enhanced agreement. That there's a termination clause.
Good.
They can get up today as Ghana.
Yes.
We can get up today and say, look, we don't want this anymore.
Yes.
And by the provision, you don't need to assign reason for the termination.
Yes.
All you need to give is 1 year's notice.
In international diplomacy, and mind you, the 98 agreement was struck through the exchange of diplomatic notes. So with those exchanges, it is the easiest way to exit. It takes another exchange of a diplomatic note to have termination.
Okay.
You see? So it was not an agreement, you know, such as this.
And it should not have been in Parliament, as he claims. That's what you're saying.
At that time,
you
know, these things came about as a result of the Jitmo 2 case.
Yes.
So when the minister speaks as though he was magnanimous to the people of Ghana and therefore had to bring this before Parliament, I mean,
You're saying that, but for the Supreme Court's decision in the Gitmo 2, they would not have taken this to Parliament.
Absolutely, because in 2001, they also, through exchanges of diplomatic notes, had similar arrangements in place. Did they bring them before Parliament? So when the minister sits here and tries to create the impression that he has been magnanimous to the people of Ghana by ensuring that this agreement was brought before Parliament, for Parliament to pass, so we should score him high marks, it is not true. He did that because he was bound to do that. In the light of the Jitmo 2 case, he had no choice in the matter. That is the point that needs to be stressed. Do you see?
Okay.
So
if materially,
yes,
they are not exactly different, so to speak, why would you insist that we are selling up our sovereignty? We are compromising our sovereignty and security.
I hold the view that the differences are fundamental I have been consistent in making my case about the fundamental differences, unimpeded access. You don't find that in the exchange of diplomatic notes of 98.
We have spoken to that point. Unimpeded access to where?
Pre-positioning of material that could be atomic bombs, chemical weapons. You don't find that in the 98 agreement. You don't find a clear-cut ouster clause of the jurisdiction of our courts in the 98 agreement, which forms the basis for the ouster of fundamental human rights.
We have just shown here that this is an improved version of that.
An enhanced version in Article 2.
An improved version where in Article 18, they now provide that unless otherwise mutually agreed, then we can go to court. But the previous one that we are speaking about, you could not go to court at all.
You see, it was better that the 98 agreement came in the form of diplomatic notes. You see, it was far, far, far better. Because when you have exchanges in diplomatic notes, it's a different ball game. The entire agreement is governed by mutual consent.
Pacta sunt servanda.
That is why you don't even find in that agreement fact that the national laws of one country would not apply. You don't find that stated anywhere.
Okay,
in fact, if you come back to the last point,
yeah.
If you come back to the 2015 agreement, there are provisions which clearly points to the fact that the parties had the fullest of respect for the national laws of either country. Several.
Which article are you reading?
Let me read Article 3. The agreement is designed to facilitate reciprocal logistical support. No, not that one. Let me take you to this other one quickly.
You're sure you haven't seen similar ones in this one?
Yes.
Respect for each nation.
Three.
Because the preamble will show you that. Go ahead.
All activities of the parties under this agreement and implementing arrangements shall be carried out in accordance with their respective national laws and regulations. Respective national laws and regulations.
Listen to this one. I'm saying the preamble. Read the preamble. The government of the United States of America, hereafter the United States, and the government of the Republic of Ghana, hereafter Ghana, hereafter referred to collectively as the parties and singularly as a party, desiring to conclude an agreement contributing to enhance security cooperation between the parties and recognizing that such cooperation is based on full respect for the sovereignty of each party, reaffirming the strong defense relationship between the parties based on a shared commitment to peace and stability. And you read further.
Something, but how can you talk about respect for sovereignty when clearly in 18 you're saying that the jurisdiction with the personnel of the United States armed forces should not be amenable to the jurisdiction of our courts? But that is not what
No, I'll come to you.
The three here is about.
I'll come to you. They are making
the three categorically talks about the
as the
respect
minister
for the national laws of
take
either
over,
country.
any residue and respond to clearly. Now, Kweku.
Wow.
Kweku has done more than a notation of the agreements in front of him. Okay, let's hear Kweku.
I'll deal with the substantive issues soon, but permit me to do a certain recollection. And nothing really changes, Nothing really changes in this country. I heard him talk about 2001. I'm not too sure what he was referring to. But you see, we're experiencing the same old story again, recycling a certain same old story. In 2003, the Kufuor administration brought to Parliament the agreement on non-surrender agreement between the Ghana government and the United States government. I don't know if you recall that. It was signed in April 2003, that's executed by the executive, and brought to Parliament in October, at the time Nana Akufo-Addo was the Minister for Foreign Affairs. And you have to read the Hansard of that day, the day of approval, 30th October 2003. Beyond that, you have to go for all the media publications and the public statements that were made. That set into operation the myth of a United States military base in Ghana. There were categorical statements made by our friends in the minority then, the NDC, and their allied groups. Some went on demonstrations, held rallies at Tamale and the rest, and claimed that there was a military base in Tamale or somewhere in the northern region. The Ministry of Defense, then led by Adokufo, issued statements denying they would not agree. Look, for 4 long years, this country was agitated on the issue of whether or not there was a U.S. military base here. It took President Bush to come, 2007. Balloon, if you remember.
Yes,
Balloon.
I remember.
Even that, they refused. The idea was that there was a U.S. military base in Ghana. Today I hear them say, yes, this agreement is bringing U.S. military base to Ghana. So there was none then. But we wasted precious time and space. 4 long years agitating, scaremongering, putting out fantastic theories. We've just been told that nuclear weapons might be brought in. Scare people. Let everybody run into a hole. We did that. We also said, and I have brought all
he has a genuine point. When you are signing an agreement, you make sure it's watertight. You take care of your interests. Don't leave anything to chance.
I'm coming. I tell you said we do the specifics. I'm just telling you how we've been what we've been doing to ourselves, so that if instead of having informed discussions based on facts and things of empirical and evidential value, what we do is to throw out all sorts of things. I said it here, it's emotions without the benefit of intellect and devoid of knowledge. They told us that agreement will bring the terrorists into Ghana. Scaremongering. They also said we had sold our sovereignty for $4 million. It's all here. The same people who are talking today. And that if they came to power, they will annul the agreement.
You say it's all here and you're referring to a Hansard of when?
The Hansard captures the process in Parliament.
Right.
But the newspaper publications, all two I brought here. That's what I mean.
Okay.
It's all
I
here.
just want you to put on record.
This
Which
is the
Hansard
Hansard.
are you referring to?
This is 30th October 2003.
Thank you.
Hansard.
Please proceed.
I have the committee's report here. Everything is here, but even the committee's report was subsequently captured in the Hansard.
All right.
They told us we had sold our sovereignty for $4 million because of the effect of this agreement. Today, they say we are reselling the sovereignty. The sovereignty that we sold, we are now reselling. You see, what I'm trying to point out is a myths, too many myths, too many, false premises are interjected in serious discussions of this sort. And then there's no informed perspective. It's dangerous, especially issues like this. I'm not professionally, technically competent when it comes to these issues. So perhaps you may say that I'm only just talking also as a citizen. There are people who can deal with these issues very well. But democracy is such that there's a wider space. So here we are. I've also been invited to discuss. So let's proceed.
I've discussed issues on tax, and I got to know that you spoke to the foremost tax persons in this country before you came here. So please,
Thank you.
please expose him. When he says what he says, don't believe him.
I do so.
Go ahead.
I do so because, you see, I realize that the audience, people who are listening, that's someone who know better than us. Look, he's sitting here, and I'm sure he doesn't like what I'm going to say. He's one of those I consult when it comes to legal issues.
I don't know you. We've never met.
And there are many other lawyers, senior ones.
I know that.
Sometimes I consult you.
I can
Samson,
testify.
because I have to. That's not my field. So I must tap on different ideas, then I put them together, I criticize, I look at which way I think I can, based on my conviction and conscience, articulate as a defense for my position.
Sometimes I've met judges who say you articulated a better legal position than some lawyers do.
I'm humbled to hear that.
Yeah, so go on.
Now, terrorists will come into town because of that agreement and this one too, we are being told. But I heard them say something about mission specific. And they talk about the 2015 one. And they were bold enough to tell all of us that it was because of Boko Haram. The Americans came here, they wanted to go and help Nigeria to fight Boko Haram, which is just across. So that cooperation, however limited, was not going to attract Boko Haram's attention. They don't have intelligence networks that, oh, Ghana gave America the base to come and fight them. I'm trying to put to you the mythical elements in what they put out. But look, we have three agreements we are discussing here. And the question is, are they the same? Are they not the same? Let me tell you something. They are the same thing different. Same thing different because in America, I have a letter here. This letter is dated June 1st, 2017. It is signed by the U.S. ambassador. Incidentally, it's addressed to my friend, Nitu. Let's read carefully. It says, in December 2015, the U.S. government proposed the Defense Cooperation Agreement as a way to facilitate a closer relationship between our two militaries and elevate our partnership. Operative word, elevate, so it's an enhancement. This agreement provides the legal foundation for enhanced security cooperation and enables a broad range of defense-related activities between us, enhancing our partnership. I'll jump. It says specifically, our proposed agreement would, 1, lay the foundation for an enhanced defense relationship. 2, upgrade our existing 1998 State of Forces agreement in recognition of this enhanced partnership. Upgrade our existing. So the 1998 one, as at the point this letter was being written, was deemed to be subsisting, or is it existing? You, the lawyers, would use the right word. 3, provide U.S. forces access to certain facilities in Ghana, enable them to make improvements and continue our cooperative activities. This new agreement conforms to standardized provisions in SOFA, that is Status of Forces Agreement. We already have with many global partners, including the United Kingdom, Turkey, and several ECOWAS countries. This agreement neither establishes nor seeks to establish a U.S. military base in Ghana. The agreement will cover our existing military cooperation and new initiatives such as the West African Logistics Network and assistance related to Ghana's participation in exercise United Accord 2018. Why I said it's same thing different is this: there are different elements, different times, different circumstances, enhancement. So obviously, it cannot be in exactitude, in terms of exactitude, the same. But our friends are creating the impression that everything in the new one actually amounts to something extraordinary and unprecedented. My brother, same thing different. The tax exemptions, were they not in the 1998 one? Are they not in the 2015 one? Go to 2015, page 7, article, waived or excluded cost.
Page 7.
What do you read there? Insofar as national laws and regulations permit, the parties shall ensure that any readily identifiable duties, taxes, and similar charges are not imposed on activities conducted under this agreement. Is this not a form of tax exemption?
Insofar as national laws and regulations permit.
But this agreement that has been signed today, no, listen, I mean, incredible. I'm not a lawyer, please. I'm not a lawyer. But once you sign the agreement, in any case,
How can you say that?
Incredible. I mean, you know, you are forcing me to say something which then can lead us to degenerate this.
So why do you doubt my integrity as a lawyer?
Okay,
Minister,
please.
The diplomatic immunity, I've dealt with the tax exemption. It's in the 1998 one. It's also in 2015. And it's also in 2018. Diplomatic immunities. Because of time, I can't read, because I think some have even come up.
Right.
Diplomatic immunities. It's in the 1998 one. It's in the 2018 one. The issue of death, I think Ace read it earlier. Yes. Both governments with anything. Yeah. It's here. It's in 1998. It's also in 2018. Then I asked myself, so what is the problem that our friends have? Because if you read their statement, they issued a press release. And according to them, the tax exemptions were an extraordinary, over-generous concession Ghana government has given.
We are not even supposed to inspect what they are bringing. So how do you know how you are going to deal with questions of tax?
You see, those things, that's why I said some of those things we are limited. But I can tell you.
Importations and exportations you won't inspect.
The same thing in 1998. At the port, first of all, there's the element of trust and everything. But at the port, not subjected to the routine, normal customs inspection for good security reasons. I can understand those things. You are talking of building capacity, training each other to fight a certain threat. The people they also have intelligence networks. If you subject those things to the normal routine customs inspection, the likelihood of leakages or somebody else looking into is there. These are high-level things. But don't forget the facilities that we've agreed on, where we have combined exercises and things. At that point in time, between me and you, our intelligence agencies know what has been brought in. It's part of the protective shield.
But isn't it too dangerous to say what you are bringing in, we will not even inspect?
Oh, I'm telling you.
And the question that arises again, Kweku, is this. Yes, previously we have had similar, engagements and agreements. But it never came to the public attention. Oh. It is now that the public is becoming aware of the content exact of these things. And the public says, no.
Yeah, the public, I'm not sure, understand, they feel, but I'm not sure they understand the full remit of these issues. They feel. And if the public are scared, I can understand. It is when my brother James is engaged in scaremongering that I detest.
So you agree with Ace that we ought to have delayed this parliamentary rush to ratify?
That's a legitimate, it's a legitimate concern you can raise. I don't think it's a fatal injury, but it's a legitimate concern. I will not attack that because that's part of the democratic framework that we are dealing with.
Yes, so you allow our representatives to scrutinize the process.
But I'm telling you, yes, I agree in principle, but I say it's not a fatal injury.
Okay.
That's my view. And we are here now, post the ratification, looking at it. It still has a certain therapeutic effect in the sense that dependent on what we say, don't forget we've given ourselves 1 year within which you can decide to pull out. If you decide to pull out, write that notice because of things that perhaps Ace them will point out later. Well, it's a basis for us to exercise that option. But I, to be honest with you, having been here for a long time, I'm not scared.
Okay.
I'm not scared at all.
All right.
You see, my brother was referring to something about exchanges of notes, and I find it very interesting. Gitmo 2, he says that is why this went to Parliament. But I've proved to you that 2003, there was no Gitmo 2. But the government took this, an agreement to Parliament anyway. Gitmo 2 verdict has only reinforced that point that we shouldn't take chances. Okay? But 2003, there was no Gitmo 2. Akufo-Addo as foreign minister sent that thing to Parliament.
But his point substantively also is that there were several others that the previous government or the government which is now in power or the party which is now in power never took to Parliament.
Which one? He mentioned 2001. The thing is 2000.
Okay.
It's 2000, the humanitarian thing. 2000. It's not 2001. I'm sure he was referring to this one, the non-surrender agreement.
Okay.
But you see, the note, is it note verbal or whatever?
Yes.
You know what? That is it's a certain format they use. But did you see that this here, the last paragraph of the American side, it says, if the foregoing is acceptable to the government of Ghana, the embassy has the honor to propose that this note, together with the ministry's reply, shall constitute an agreement between the governments which shall enter into force on the day of the ministry's reply. Now, all you have to do is to go, and the American war was dated 19 January, January 1998. Now, when you come to the attachment, which is from the Ghana side, all the Ghana side did was you recopied. They just recopied the American one. Then they come to this point, and this is the critical point. The Ministry of Foreign Affairs has the further honor to inform the Embassy of the United States that the proposals set forth in the embassy's note are acceptable to the government of Ghana, and to confirm that the embassy's note and this note shall constitute an agreement between our two governments which shall enter into force on this date. So, and I'm doing here, what I'm doing is a bit uneducated. So if it says because they are notes, you can easily pull out. I said no. It means if you send a note to them, they must respond to your note. Okay?
You can't pull out unilaterally as he suggested.
That's the point. That's the point. I believe that the greater credit goes to those who will bring such things to Parliament. Whether a court order or not, once it gets to Parliament, the people of this country and our representatives in Parliament have been given the chance to interrogate it.
But isn't it the case that unilaterally you can pull out, except that there will be legal consequences?
Yes, but if you can, but he was creating the impression that it's just a one-sided, simple, straightforward way.
All right.
Okay? And that's not reflection, true reflection of how these things work.
Okay. So this is what I'm going to do, Kweku.
Yes.
I'm taking a break here. We will return, and when we return, we are going to hear the minister look at all other matters residual that has come forward and answer the people's question, what is in it for Ghana? We'll be right back.